Listing broker cannot disclose halfway house for recovering alcoholics. Question. The listing broker has a listing on a home. The listing broker learns that there is a halfway house for recovering alcoholics next door. Can the listing broker disclose the existence of this halfway house to prospective buyers? Answer, no. The recovering alcoholics in the halfway house are disabled and therefore are members of a protected class under the Fair Housing Laws. See ARS, Paragraph 41 1491-5. Therefore, the seller and the real estate brokers are prohibited from disclosing the existence of this halfway house, similar to the prohibition against disclosing individuals in the neighborhood of a certain race, religion, sex, or any other protected class. Note: only recovering alcoholics are a protected class under fair housing laws. Although alcoholics that are not recovering may have a disability, the protection of the fair housing laws specifically applies only to recovering alcoholics. Sue note: professional office building owner and tenant are obligated to make public restrooms wheelchair accessible. Facts. The commercial office building was constructed in 1960. The building has multiple offices and rents office space to various types of business. The owner, landlord, recently rented office space to a tenant who operates a professional services business, tenant, and who happens to have a disabled employee that requires the use of a wheelchair. Employee. The door to the office bathroom is only 24 inches wide. In this regard, the employee's wheelchair will not fit through the bathroom door, and the employee cannot access the bathroom. Issue. Must the landlord and/or tenant alter the bathroom so that it is accessible to a disabled person in a wheelchair? Answer. Yes. Title III of the Americans with Disabilities Act, ADA, covers, in pertinent part, places of public accommodation and commercial facilities and extends to private entities. See 28 CFR PR 36.101 et al. Pertinent here, places of public accommodation are facilities whose operations affect commerce and include various categories enumerated under the ADA. Of these categories, service establishments such as offices of accountants and lawyers, insurance offices, and professional offices of healthcare providers are included. According to the ADA, both the landlord and the tenant have full responsibility for complying with all of the Title III requirements applicable to that place of public accommodation, i.e., the tenant's office. The Title III regulation permits the landlord and the tenant to allocate responsibility in the lease for complying with particular provisions of the regulation. However, any allocation made in a lease or other contract is only effective as between the parties, and both the landlord and the tenant remain fully liable for compliance with all provisions of the ADA relating to that place of public accommodation. Title III of the ADA prohibits discrimination against any individual with a disability. Accordingly, individuals with disabilities may not be denied full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations offered by a place of public accommodation. Under Title III, architectural barriers must be removed when it is readily achievable to do so. According to the ADA, architectural barriers are physical elements of a facility that impede access by people with disabilities. Determining if barrier removal is readily achievable is necessarily a case-by-case judgment under Title III. However, the ADA presumes that widening doors is readily achievable. That being said, in this case, it would likely be found that widening the bathroom door to accommodate the employee's wheelchair would be readily achievable. Therefore, the landlord and the tenant are responsible for accommodating the employee by widening the bathroom door for wheelchair accessibility. Note: this does not address Title I of the ADA dealing with an employer's obligations to a disabled employee with respect to making accommodations, as this would be outside the scope of the AAR legal hotline. See you note. The property management company cannot require compliance with swimming pool barrier laws. Issue: the property management company has a swimming pool barrier policy for tenants with children. This policy requires tenants with children to install a fence or otherwise comply with swimming pool barrier laws. Furthermore, at the termination of the tenancy, the tenant is required to remove the fence or other improvements at the tenant's expense. Is this policy in compliance with fair housing laws? Answer: probably not. Familial status, such as tenants with children, is a protected class under fair housing laws. If the property management company has a policy that places conditions or restrictions upon the rental because of familial status, e.g., compliance with swimming pool barrier laws, the property management company has probably committed a discriminatory act under the fair housing laws. See ARS, Par 41, 1491.01, SU Note. Real estate licensee must comply with Fair Housing Act even with personal residence. Facts: a real estate licensee owns a single-family residence. The garage of the home has been converted into a small studio apartment. The licensee wants to advertise the studio apartment for rent to a single person. The licensee believes she can advertise for single tenants because she is exempt from the fair housing rules as her property is an owner-occupied property. Issue: can a licensee advertise her studio apartment for rent to a single tenant only? Answer: no. Discussion: a homeowner cannot publish a discriminatory ad or advertise in violation of the Fair Housing Act. There are, however, limited circumstances where a guest house of an owner-occupied property can be restricted to single persons or a specific gender. Regardless, these limited exceptions to the Fair Housing Act do not apply when a real estate licensee is involved in the transaction. See 42 U.S.C., paragraph 3603, SU a note. Seller cannot refuse showing to handicap buyer. Facts: the buyer's agent contacted the seller to arrange a showing. It was a rainy day and the seller asked the buyer and agent to remove their shoes before viewing the property. The agent notified the seller that the buyer is in a wheelchair, but indicated the buyer would stay on tiled flooring areas. The seller stated he did not want the buyer in his house because he had carpeting throughout the house. The agent asked if the buyer could view the house on a day when there was no rain. The seller refused and said the buyer could not view his house because he didn't want a wheelchair in his house. Issue: can the seller refuse to allow a potential buyer in a wheelchair into his house? Answer: no. Discussion: Arizona Revised Statute, ARS, paragraph 41, 1491, 19, entitled Discrimination Due to Disability, states, a person may not discriminate in the sale or rental or otherwise make unavailable or deny a dwelling to any buyer or renter because of a disability of 1. That buyer or renter. Emphasis added. Further, the Fair Housing Act prohibits the refusal to otherwise make unavailable or deny a dwelling to an individual based on a handicap. Therefore, the seller cannot prohibit the buyer from viewing his property, or he has violated fair housing laws. Independent counsel should be consulted. SU note. Buyer not liable for flooding after turning on of utilities. Issue: at the time that the short sale was approved, the seller was no longer in the home, and the utilities were not on. The listing broker tells the buyer that the seller has no money to turn the utilities on for the home inspection, and that the buyer should turn on the utilities. The buyer telephones the city to turn on the water, but when the city turns on the water, the home is flooded. The home inspector was unable to do the home inspection because of the flooding, and the buyer canceled the contract. Is the buyer liable to the seller for the flooding of the home? Answer: no. In essence, the seller designated the buyer to be the seller's agent to turn on the utilities. The buyer was never able to do a home inspection. Therefore, there is no liability of the buyer under lines 193 and 194 of the contract for damages due to a home inspection. Sue note. Buyer's failure to investigate does not excuse seller's fraud issue. The seller of a vacant lot knows that the vacant lot is in the floodplain, but intentionally and fraudulently fails to disclose that the vacant lot is in the floodplain. Although the buyer could easily discover during the inspection period by inspection of county records that the vacant lot is in the floodplain, the buyer did nothing. After close of escrow, the buyer learns that the vacant lot is in the floodplain and that the buyer will not be able to build a home on the vacant lot. Is the seller liable for the intentional and fraudulent non-disclosure of the floodplain status, even though the buyer may have been negligent in failing to investigate the floodplain status of the vacant lot? Answer: probably. The general rule is that the recipient of a fraudulent and intentional misrepresentation occurring either by commission or omission is justified in relying upon the truth, although the recipient may have ascertained the false representation had the recipient made an investigation. Restatement, 2nd, of Torts, Power 540, Barnes v. Lopez, 25 Arazi. App. 477, 544, P. Tude, 694, Sitar App, 1976. After seller made a fraudulent and intentional misrepresentation as to the zoning status of the property, the buyer was entitled to rely on this misrepresentation and had no duty to make further inquiry.